Thank you for joining and hope everyone's doing well. So we are slowly going back to normal, and it's actually good news, but we still need to do all those precautions and stay safe, and hopefully we will have the vaccine for this COVID-19 very soon. So for people who don't know me, let me just introduce myself. My name is Attorney Khoshvaght. I'm an immigration attorney practicing in Los Angeles, California, and I have been having these weekly workshops that every week I will discuss and talk more about a specific area of immigration law with you guys, and it's actually an educating sessions and live videos, and hope it has been helpful for you guys and you watched our other videos. So today I'm going to discuss about how to apply for your green card as under the Violence Against Women Act law, and it's actually a type of self-petitioning, which is called Violence Against Women Act, or VAWA self-petition, which if you are qualified and you have certain requirements, you would be eligible to apply for your green card through that. So first of all, I want to explain to you what does this Violence Against Women Act mean. So it's actually, this law is to protect people, specific and certain people that I will tell you later. It protect them from abuse and abusive relationship that they have, and it's actually a protective act for those people. So it would allow them to apply for their green card and get their VAWA status, which is Violence Against Women Act. So although it has women in it, it doesn't mean that if you you are not women, you wouldn't qualify. If you're men, you wouldn't qualify. If you qualify and you have those certain requirements, you might be also eligible to apply for this green card, because the abusive relationship does not all the time happen or occur only to women, and sometimes men are actually the victim of abusive relationships. And so although it has the women and the name, it doesn't mean that if you're a man and you qualify, you cannot apply. So you might still qualify. So the general categories of people who might qualify under this VAWA self-petitioning and applying for their green card through that, or if you have been a subject of extreme cruelty or battery by your U.S. citizen or lawful permanent resident spouse, either this abusive spouse is your current spouse or was your former spouse. So it's not only U.S. citizen spouse, as I said, either U.S. citizen spouse or lawful permanent resident spouse. And the second category is if you if the petitioner has actually been subject to extreme cruelty or battery by either U.S. citizen parent or lawful permanent resident parent. And the last category is actually for for the parent of a U.S. citizen, son or daughter, child, that actually have been abused or in an abusive relationship with their son or daughter. So the only difference for this category is that it would only apply if you are a parent of a U.S. citizen child. So if your child is a lawful permanent resident, unfortunately, you wouldn't qualify under this law. What you need to do in order to apply for this VAWA petition is you need to file a form which is called I-360 form, which is specifically for it has actually other types of petitions. One of the petitions included in this form is for people who wants to apply for VAWA. And another thing that you need to know is sometimes people would even qualify to concurrently file their VAWA self-petition and their I-485 application, which is the application for green card, like applying for a green card. So concurrently means like they file these two forms, like the I-360 and the I-485 at the same time. So USCIS would adjudicate these cases together, so you do not need to wait first for approval of I-360 and then apply for a green card. And this type actually apply for people who are actually living in the United States, and it doesn't matter in what type of status they are, even though you are undocumented and you do not have lawful documentation, you might still qualify to file your VAWA application and I-485 application at the same time, if for sure you qualify and you have those other certain requirements. So I will actually explain to you the requirements for each of the categories that I told you. So for example, how a person who is a spouse of a U.S. citizen or lawful permanent resident could qualify for this VAWA self-petitioning. For the spouses, there are actually certain requirements for the spouses that need to show to USCIS in order to prove their eligibility for VAWA. You could definitely show these requirements by providing evidence and documentation to the USCIS. So the first requirement for the qualifying spousal relationship is that you are married to a U.S. citizen or lawful permanent resident. So how could you show that if you are married? Your marriage certificate. So you would show your marriage certificate to USCIS, so you would include that in your packet. That would show that you are currently married to a U.S. citizen. And please note that this whole VAWA act is to protect the abused person. So they are very cautious about these applications, USCIS. So all the information are confidential, and they would not share those information with the abusive spouse, parent, or child. So most of the time, the reason why you could still apply for this VAWA petition while you are still married to a U.S. citizen is in fact to protect you. So most of the time, like these people, like the person who is in an abusive relationship, they are actually afraid to file their petitions or applications because they are afraid that they are caught by their parent, they are caught by their spouse, or by their child. So that's why all information is confidential, and USCIS would not share it with the abusive person. So this is one of the reasons why you could still apply for this type of petition even though you are already married to your US citizen or lawful permanent resident spouse. So this is the first. Or even if you are not currently married to your US citizen spouse, you might still qualify if your marriage to the abuser was terminated either by death or divorce. That is actually, the divorce is actually related to the abuse. So you need to show that you divorced your prior spouse because of the abusive relationship. So and this death or divorce should have been occurred within 2 years prior to filing your petition. So that's actually a requirement if you are not currently married to your US citizen spouse or lawful permanent resident. And or the law says if your spouse lost or renounced their citizenship or permanent resident status within the last 2 years prior to filing due to an incident of domestic violence, you would still, you might still be qualified to file this petition. And another option is if you believed that you were legally married to your US citizen or lawful permanent resident spouse, but the marriage was not legitimate solely because of the bigamy of your abusive spouse. So these are the first requirements to show that you are actually in a qualifying spousal relationship in order to meet the first requirement for VAWA self-petitions. And then the second requirement is for sure to show that you have been in fact either battered or you were suffered extreme cruelty by your US citizen or lawful permanent resident spouse. Or you could also show that your child has been subjected to battery or extreme cruelty by your US or permanent resident spouse. So either you or your child. And the third requirement is to show that you in fact entered into the marriage in good faith. And it wasn't solely for the purpose of receiving any immigration benefit. And the other one is you need to show that you have resided with your spouse. And also you need to show that you are a person of good moral character. So I need to make some notes about these last 3 requirements. Last 4. So regarding the extreme cruelty and battery, please note that it doesn't have to be that, for example, you have been beaten by your spouse, or he or she hits you, or it doesn't necessarily need to be physical abuse in order to qualify for extreme cruelty or battery. Even emotional abuse would also qualify. For example, if your spouse constantly threaten you of deportation, or he or she calls you illegal in front of other people, or he or she threatens you that they might call ICE or immigration officers to pick you up and deport you from the United States, or they verbally abuse you. So the abuse has a broad meaning, so it doesn't necessarily mean physical abuse. So please keep that in mind. For the good faith marriage, how you could show that your marriage was in good faith: joint bank accounts. If you had a wedding ceremony, pictures of your wedding ceremony. If you have pictures with your family members or his or her family members, like those pictures, or if you have health insurance together, like any joint documentation would work if you file your taxes together. So these are the documents, examples of the documents that might be helpful in your petition to show that you actually entered into a good faith marriage and it wasn't only for the purpose of getting or receiving an immigration benefit. And for the requirement that you have resided with your spouse, so for sure if you have been living in the same residence, so the lease agreement would work. If you paid for utility at that address, those are the documents that would be helpful. And one thing I forgot to say about the examples of abusive relationship, if you have been subjected to extreme cruelty, is when the spouse, either your U.S. citizen spouse or lawful permanent resident spouse, actually tries to withdraw your immigration application. For example, you married to your U.S. citizen spouse, you entered into the marriage in good faith, and you loved your spouse and everything was working well, and then suddenly your spouse started this abusive relationship, and in order to hurt you or threaten you or continue the abuse, they either withdraw the immigration application that they filed on your behalf, or threatening you all the time that they're going to withdraw the application, or they will not ever file for your green card because they want you to be outside the country and they want you to be deported. So this is also another example. So even if you have an application pending with USCIS, this is a very common question from people who are in abusive relationship and they are afraid to get out because they say they have this application pending with USCIS and they don't know what to do. So that's why we have this VAWA Act to protect the abused person. So if you are in that situation, you might still qualify if you have other requirements. So having an immigration application that's filed by your spouse on your behalf does not actually bar you to file for your VAWA petition. So please keep that in mind too. And you also need to show that you are a person of good moral character, so you need to show police clearance reports from the states that you have been living there for over 6 months. And these are for requirements for spouses of U.S. citizen or lawful permanent residents. For sure, there are many specific facts for each person, for each case that might need a deeper evaluation to see if the person qualifies. So if you believe that you, unfortunately, you are in an abusive relationship with your spouse, and you want to think about this option if you do not have your immigration paperwork yet, so contact an immigration attorney. You could definitely call our office 424-402-7053 to make an appointment for consultation to evaluate your case for this category. Now I'm moving to the second category that I told you is eligibility requirements for a parent. So you need to have a qualifying parent son or daughter relationship. So how could you show that? Your birth certificates, because your parent's name is actually written on your birth certificate, right? So you could show that. And then you need to show that you are the parent of a U.S. citizen son or daughter who is at least 21 years of age when your self-petition is filed, or you are the parent of a U.S. citizen son or daughter who lost or renounced citizenship as status related to an incident of domestic violence, or you are the parent of a U.S. citizen son or daughter who was at least 21 years of age and who died within 2 years prior filing your self-petition. And the second requirement, like the spousal relationship, is that you have been in fact suffered battery or extreme cruelty by your U.S. citizen son or daughter, and you have resided with the abusive son or daughter, and you are a person of good moral character. So again, you need to show evidence for these, like and how could you show that you have been in abusive relationship? You could for each of these categories, you could use affidavit of supports, like letters from friends or family members who could assert that you have been in fact abused. And if you have any doctor report, like medical reports showing that you have been in a domestic violence relationship. And the main and most important one is you get a psychologist report from a registered psychologist and well-known psychologist who is actually experienced in these type of cases, and get those psychologist reports that will show how this abusive relationship either it was from your spouse, your parent, or your child, in fact affected your mental health. And these psychologist reports are very important. And the main one is your own declaration explaining how you have been in that abusive relationship. And for sure, if you are in an abusive relationship, you have access to resources by your county that you are at, that the self-help programs, or the agencies, the institutions, the pro bono institutions that could help you, and keep all those contacts, letters you sent for help, keep them as an evidence so that you could use them in your applications. For example, if you have ever called a police officer on your spouse, parent, or child, keep that police report. If you ever filed a restraining order on your spouse, keep those and document so that you could show later that you in fact been abused, to help your case. And the last one is the eligibility requirements for a child who who has been in an abusive relationship. So again, you need to show a qualifying child-parent relationship, which you could show by your birth certificate, and you show that you are the child of a U.S. citizen or lawful permanent resident parent, or you are the child of a U.S. citizen or lawful permanent resident parent who lost citizenship or lawful permanent resident status due to an incident of domestic violence. And then also you need to show that you have suffered extreme cruelty or abuse and by your parent, and you have resided with your abusive parent, which, as I said, you could show by the lease agreement, rental payments, and similar documentation. And also you are a person of a good moral character. So for a child, if you are less than 14 years old, it is presumed that you are a person of good moral character, so you do not need to get a police clearance report for that. And as I said, you must complete the form I-360, and if you are filing concurrently with your the I-485 application, you can concurrently file those. If you are a preference category and you're like, for example, the immigrant visa is not yet available to you, so you wouldn't qualify to file for your I-485 status. You need to be your visa needs to be current in order for you to concurrently file your I-360 and I-485 applications together. So one of the main examples of when people can file concurrently is when you are the spouse of a U.S. citizen, and if you are in the United States, even though you do not have any documentation and you are undocumented, or you are subject to those 3-year or 10-year bar rules, you could still apply concurrently for both your I-360 petition and I-485 application. And you could also, when you concurrently file for your green card with your VAWA petition, you could also apply for work authorization. And even if you do not qualify for filing concurrently, if you only file the I-360 petition, if your I-360 petition is approved, you would qualify to apply for your work authorization. And even when it's pending, if it's pre-approved, your I-360, you might qualify to receive certain public benefits with that pre-approval of your I-360 petition. I know it's a lot of information, so I don't want to make you confused, but I'm just giving you general information. So if you have specific questions, call our office and we would be happy to help you if we could. So and these are actually the general requirements, and now I want to discuss about the grounds of inadmissibility, because if you are going to apply for your green card, you need to, even though you have either pending I-360 petition like the VAWA petition, or your VAWA petition is approved and now you're ready to file for your green card, you must be admissible, right, to the United States. So there are certain inadmissibility grounds for VAWA self-petitioners that are actually waived. So VAWA self-petitioners will be exempted from these certain grounds of inadmissibility. For example, if you have been subject to the 3-year or 10-year bar, which basically means if you have been living in the United States either after your visa expired, or you have not had any documentation, you have been living in the country for over 6 months, and you are subject to the 3-year bar if you leave the country. And the 10-year bar would apply if you have been living in the US for a year and more, and you did not have any either documentation or you lost your status. Then you will be subject to the 10-year bar. So for VAWA self-petitioners who are applying in the United States and they qualify to apply for their adjustment of status in the United States, they wouldn't be subject to this bar because they're not leaving the country, right? They're applying in the United States. But for people who are outside the United States, what they need to do in order to be exempted from this 3-year and 10-year bar is if they could show that your presence in the United States, even though it was without the documentation or status, was actually connected to that abusive relationship. So you were suffering abuse, and that's why you had to stay in the country without the documentation. And if you are outside the United States, you might still be able to claim an exception, as I told you, to the 3 or 10-year bar provision if you could show the connection to the abuse. And there is another one, which is the permanent bar. For example, if you have been deported from the United States and you re-entered the U.S. after your deportation. So there's also normally for permanent bar, you couldn't do anything because permanent bar is actually a bad thing on your immigration record, and most of the time it's not good for your case. But for VAWA self-petitioners, if you could show that there was a connection between the abuse that you suffered and your removal, departure, re-entry, or any activity that actually triggered this bar, if you could show the connection to abuse, you might actually qualify to apply for your green card when you are outside the country, and you wouldn't be subject to the permanent bar. And another exception is for public charge rule. We talked a lot about public charge rule, and I already have had videos about this. So public charge, one of the exceptions is for VAWA self-petitioners. And if also you are subject to ground of inadmissibility of fraud or misrepresentation, normally you would need to file a waiver, I-601 waiver. For VAWA self-petitioners, you only need to show that you qualify for the waiver, because if you are not approved, there will be extreme hardship either on you as the applicant and your qualifying parent or child. Normally, for other types of cases that are not VAWA cases, you need to show for fraud or misrepresentation that if your actually green card application is denied, there will be extreme hardship on your U.S. citizen or lawful permanent resident parent or spouse only, and extreme hardship on you doesn't matter. But for VAWA self-petitioners, if you could show that there will be extreme hardship on you alone, you might qualify for this type of waiver. And then for criminal grounds of inadmissibility, you do not have to show that a qualifying relative will suffer extreme hardship if your application is denied, but you need to show that you are a person of good moral character. So these are for the grounds of inadmissibility that I wanted to cover. This is actually, for sure there are more to say and talk about VAWA self-petitioning. I don't see any question here. And if for sure you have questions about this subject, you can reach out to my office at 424-402-7053. And it is very unfortunate to be in an abusive relationship, but if you are in that type of relationship, or if you know someone who is in that type of relationship, please help them and help yourself and get help. There are a lot of resources that you could reach and get help, because being in a domestic violence relationship or abusive relationship is not healthy, is not good for your mental health. If you have a child, it's not even good for the mental health of your child. So get help, and I hope that none of you ever be or have been in those types of relationships. So if you have any questions, as I told you, call our office. Thank you very much for joining us, supporting us, watching our videos, subscribing to our YouTube channel, and hope all these videos been helpful for you guys. Thank you very much. See you next time.